We'll get started in 1 minute. Good afternoon, everyone. Welcome to our webinar today, hosted by the Statewide Independent Living Council of Illinois. And our presenters are going to be from Hope Fair Housing, and they're going to do a presentation about fair housing. We're very glad to have you here with us today. My name is Shelley Richardson, and I am the Executive Director of Silk. My pronouns are she, her, and for visual access, I will give you a description of myself. I am a white female, chunky, middle-aged, short red hair, wearing glasses, and a pink-colored, rose-colored top today. So let's get underway, and I want to introduce to you Michael Chavarria. Michael is the Executive Director of Hope Fair Housing Center. And Michael joined the Wheaton, Illinois-based Hope Fair Housing Center in January 2022 as its executive director. His career has been spent working in various capacities within the fair housing movement at several Illinois-based housing advocacy organizations. Michael grew up in the Matson, Illinois, as it was being transformed by some of the nation's fastest documented white flight, and has since dedicated his career to working alongside those most impacted by the housing discrimination and community disinvestments to advance fair housing. In just a minute, I will turn it over to Michael, and he can introduce his other panelists that's with him here today. But for housekeeping purposes, I want to let you know, Michael, do you want to take questions as they occur, or wait till the end?
I think if we can save them for the end,
Okay.
And we'll have a good amount of time left for that.
Okay. Well, we have two settings. We have the chat setting. If you are having some kind of technical difficulties, we have my right hand here, Tara Dunning, here in the office, and she can help you with that. But also, if you will put any questions you have in the question and answer tab at the bottom, then we'll take those questions at the end. Tara will keep track of them. Also, at the end of the presentation, if you do not have the ability to enter your question into chat, you can, there's a button down there that says raise hand. You can click raise hand. Tara will see that you have raised your hand, and she will unmute you, and you can go ahead and ask your question then. I also want to remind you that at the end of this webinar, there will be a poll. It's a very brief poll, and it's very important that we get your feedback. So if you would be so kind as to not just click out without answering the questions on that poll, we would appreciate it. Okay, Michael, I'm going to turn it over to you.
Thank you so much, Shelley. And thank you everyone for joining us today. We're really excited to be here to be talking about the topic of fair housing with an emphasis on source of income. As Shelley mentioned, I'm coming today from Hope Fair Housing Center. My colleague Isabel, who I'll be passing it over to shortly, will tell you all about what Hope does and kind of walk you through our plan for our discussion this afternoon and how we plan to approach the conversation. In terms of visual access, I am a white man with dark brown hair. I have a full beard and somewhat messy, semi-curly hair. I'm wearing a gray blazer over a orange shirt, and I'm standing in our office in Wheaton. And right behind me is a pretty cool banner that says Hope Fair Housing Center. And I just love it because the word hope is made up of all sorts of words related to the work we do, combating discrimination and trying to deconstruct segregation. So that's who I am. I use pronouns he, him. And again, I'm very excited to be here with you. I'm going to pass it over to Isabel, who's going to get us kicked off, and then I'll be joining back on to talk about source of income protections specifically. So all yours, Isabel.
All right, thank you so much, Michael. My name is Isabel Anderson, and I use she, her pronouns. I also work at Hope Fair Housing. And for a visual description, I am a white woman with black hair, chin length hair, gold earrings, and a red collared top. And I will be kicking off the presentation today. I don't know how many people here are familiar with the concepts of, that often pop up in fair housing. But I will be laying a little bit of a groundwork, a little bit of leveling so that we're all on the same page. Just want to make sure that everybody can see the presentation on their screen before I go ahead. All right.
Yes,
Perfect.
it is visible. Yeah.
Thank you. Wonderful, wonderful. And so wonderful. Today we are going to be going over a huge and emerging topic in fair housing, which is source of income. But first, we will do the basics. Could I have the next slide, please? Let me see. Oh, yes. So we've gone over who we are. I am outreach coordinator, and Michael is our executive director. And today I will be going over our agenda. First, what is Hope? A little bit more about us, a little bit about the history of fair housing, what is source of income, and then to sort of address some of the issues that we'll be bringing up. Hope Fair Housing has created a wonderful SOI toolkit to help community members tackle this issue. And finally, how Hope can help in a broader sense. All right, next slide. First, a really quick disclaimer. We are not lawyers, and this is not to be intended to be used as direct legal advice. We always say, if you have a specific issue, it is best to consult a lawyer on your specific case. But we are here to provide education, outreach, and resources to inform the public about their fair housing rights. Next slide, please. So, many of you may have heard of Hope Fair Housing, and many of you may have not. So we are a nonprofit located in Wheaton, Illinois, that is working to create greater opportunities for all. We want to live, and I'll dig later more into this definition, but we want to make sure that everyone has the chance to live in the place of their choice, free from harassment or legal discrimination. And that involves intake, which is listening to people calling in and saying, hey, this happened to me. I'd love to talk to somebody about it and to hear more about it from people who are, whose job it is to know what the rules are and know how to tackle issues. Testing, policy change, investigation, outreach, and education. And you guys right now are a part of an outreach and education element of our mission. So thank you all again for coming. This is a big part of who we are, and we're really focused on spreading awareness and knowledge and empowering people to take fair housing into their own hands. Next slide. Where is our service area? Our service area, we serve over 30 counties in the northern and north central parts of Illinois, and we're in the middle of expanding. So everything you see here in blue is our service area, and some of those dashes are our partial service area. So if you see yourself in there, or you see someone you know, have them give us a call if they ever run into problems. Next slide, please. Now, so a big moment in fair housing that we always point to is the Fair Housing Act of 1968, which was a huge moment in our histories, in our history, and it really put into law the prohibition of discrimination in renting, leasing, buying, selling, or occupying a dwelling because of a person's membership in a protected class. And while this did not obviously eradicate all discrimination forever, it was a huge step in the right direction to where we are today, and has really set the foundation for the work that we do. Next slide, please. So earlier I alluded to a little bit of that definition, but here it is all spelled out. We want people to live where they choose, have access to have access to housing, and enjoy the full use of their home without unlawful discrimination, interference, coercion, threats, or intimidation. It's a basic human right, and every person on this call and in this state of Illinois should be able to have it. So that's what we're working towards. Next slide, please. and also the United States and the whole world, not just Illinois. So in our practice, we see a couple different types of discrimination, but today we're going to go over the ideas of direct discrimination and disparate impact. So everyone is more familiar with what direct discrimination is. It's treating someone less favorably based on their membership in a protected class, perhaps saying, we don't take Section 8, or no Italians, no African Americans, no, fill in the blank. An example of that would be a landlord refusing to rent to someone because they have children, which takes a prohibited act and combines it with the prohibited class to equal discrimination, which is part of an equation that we will dig into later. Now, a disparate impact is a little harder to suss out. It's slightly more insidious. So it describes the impact of a seemingly neutral policy that in practice affects one protected class more negatively than others. For instance, a housing provider refusing to accept disability assistance to pay for rent from tenants with disability. So that means effectively that people with disabilities are barred from certain housing, and that is discrimination. And we will continue to see what that looks like with this equation. Thank you. So, like I said before, it is a prohibited act plus a protected class equals discrimination. So you need both of these for it to be illegal discrimination. And we will get into some examples as well. Next slide, please. But many of you are probably, oh, actually, Michael, could you go back? I like to do my little test. I forgot. In Illinois and federally, we have several protected classes, like right here in the second part of this equation. And what I like to do at this point of the presentation is ask if anybody knows them. If you were quick-eyed and spotted some of them, that's okay too. But feel free to pop any ideas into the chat of some some protected classes that you think there could be in Illinois or the state or the United States. Let's see. And we will keep, let's see, we've got a raised hand. If possible, I'd love to see it popped in the chat just so people can toss those in there and I can talk about them while I'm presenting. But let's see, I'll give it another second. Well, I will keep going and we'll see if anybody, people with disabilities. There we go. Thank you so much, Shelley. So next we'll go to the reveal. Thank you, Michael, for the next slide. So we've got federally race, disability, sex, national origin, color, religion, and familial status. And statewide, we have sexual orientation, ancestry, marital status, gender identity, arrest record, age above 40, order of protection status, military status, source of income, which we'll be talking about today, pregnancy, and as of January of this year, immigration. So these are the protected classes that we have that Hope rallies around, and we do work pertaining to these classes. Now, I could have the next slide, we will look more on what a prohibited act. So this is that first part of that equation that we saw, which is an instance in which a person is harmed or treated differently in a manner that denies them housing or the ability to enjoy their housing. So this plus a protected class equals illegal discrimination. So we've got some examples like charging additional or higher fees, perhaps because of an immigration status, saying, oh, well, you don't have a social security number and you might be a flight risk, so we're going to need to charge some additional fees. That is illegal discrimination. Perhaps ads or statements that exclude a certain group, saying, no Section 8, or refusing to rent or lying about housing availability if a Black family applies for housing and housing provider says, no, we don't have any. We don't have any kind of availability, but they are lying. Hope Fair Housing and other fair housing advocacy groups can come in and sort of assess the situation and try to figure out what can be done. But those are some examples of prohibited acts. And we just saw the definition of what a protected class is. So now we will move on to some more examples. So we've got a little quiz here. Mary is searching for affordable housing in her neighborhood for herself and her family. While on a scheduled tour of the apartment, Mary mentions her children. The landlord informs Mary that he doesn't allow families in his building because they cause too much noise. Is this a prohibited act? All right, so now here is where we test our knowledge. Does anybody think, feel free to pop it in the chat. Does anybody think, is this a prohibited act? And if so, what do we think the protected group is? We can hold just for a second for people to reread it. Any ideas? That's okay if not, because it's a learning environment. I will tell you. Don't be afraid. Oh, chat is disabled for attendees. Okay. All right. Well, then I will pretend that I heard a cacophonous sound and went to the chat and saw. Does anybody else? Well, yes. So this is a prohibited act. So familial status is the protected group, and the prohibited act. Okay, perfect. It looks like we've got a little bit, we've got some changes. It looks like the chat has been opened up. Luckily, we have another. Does anybody have, I spoiled one thing, what the protected group is, but does anybody know what the prohibited act was here in this example? We've got, in my imagination, participants are just waiting to answer and have so many answers boiling up inside of them. But denying someone because they have children is illegal. So that is the test your knowledge answer for this example. And now we can go to this next slide. Thank you, Michael. Oh, familial discrimination. Way to go. Okay. Brianna, a Hispanic woman, has spoken on the phone with a prospective landlord and has made an appointment to see an apartment. However, when she arrives and meets the landlord in person for the first time, he tells her that the unit is no longer available and that there is no point in her finishing the paperwork. Is this a prohibited act? I'll wait for just a second to see if anybody has any ideas. I'm looking for two answers, a possible protected class and a possible prohibited act.
I would encourage you all to participate. This is your knowledge base. Please type your answers into the chat.
Well,
This
or
one I
use
will
the
say.
Q&A.
Yes, or people are using the Q&A. Okay.
Yeah, use the
That is still disabled. Okay. That is okay. Well, maybe we can
just use the Q&A.
Yeah, let's just use the Q&A. So if you have an idea, go ahead and pop your answer in the Q&A. And I will let you know this one is a little bit of a sneaky one. So don't be afraid. This one's a little bit of a sneaky one. The first one was a gimme. And the second one, this one's a little tougher. So, but I'd love to see what people are thinking in the chat or in the Q&A section. So go ahead. And if you toggle over, let's see, we've got answered.
Can you see the Q&A, Isabel, or I can read them?
I can see, still showing the chat for me. Oh, yep, I see it. Okay. So we've got Tanya is saying, I think the scenario is valid, especially since the unit is no longer available. And then we've got Aaron saying this is a prohibited act. So this is some great thoughts that we have here. And this answer is tricky because these two elements alone are not enough to equate to an illegal discrimination because we don't know why the unit is no longer available. Perhaps the unit truly is no longer available. We don't know necessarily that it is a race-based disqualification. So this is an example where Brianna could call Hope Fair Housing and say, hey, I'm not sure what's going on, but I applied at XYZ apartments buildings and everything was going smoothly until I went and he saw that I was a Hispanic woman and suddenly it's no longer available. And that would be a really great area for a fair housing group to come in and say, okay, well, let's assess the situation. Has this happened to other people? Does this housing provider have a history of behavior like this? And are there ways that we can sort of set up self-advocacy letters or a dialogue with the housing lender to find out why the root of this issue. If the unit is no longer available, then the unit is no longer available. But if we observe a troubling pattern based on race, then that is absolutely could be considered illegal discrimination. So that first one, easy, cut and dry. We don't allow kids here. Actually, that's illegal, and that is illegal discrimination. But this second one is more insidious and a little harder to sniff out. But that's why Hope Fair Housing exists, because we are here to investigate, we are here to test, and we are here to help arm the community with the tools to advocate for themselves. All right. Great job. Thank you so much, Tanya and Aaron, and for sticking with me through our chat difficulties. I will now advance the slide one more time. And this is actually, I believe, the end of my section. So thank you so much for joining me for the opening section of our presentation today. I will now hand it over to the wonderful Michael, who will be talking about our specific topic today, source of income.
Awesome. Thank you so much, Isabel. So real quick, I just want to give everyone a heads up. If you notice me turning my head to the side, I made a mistake in how I set up my slides, and I'm too scared to try and fix it. I'm worried I will somehow mess everything up. So you might see me having to look away just as I advance the slides. One thing I want to call out that Isabel just shared right at the end, if there's one big takeaway, it's that while we're providing this educational information about what fair housing protections cover, what your rights are under the laws, what recourses you have if your rights have been violated, there's one thing we want to make sure to communicate, and that's that we don't anticipate everyone who's doing very busy jobs, doing very important work, supporting different communities and meeting different needs to become fair housing experts. Our goal is for folks to walk away from these trainings with enough information to be able to identify when discrimination has likely occurred, and then to use us as a resource, right? So like a lot of folks on this room or in this room, your organization is probably like us, funded through taxpayer dollars, through taxpayer programs, and so are we. So we really can treat that as a responsibility. So we are here to help people. If you have a client who's experienced discrimination, give us a call, have them give us a call. If you think someone, a housing provider, is discriminating against your clients, shoot us an email, give us a call. We don't need you to necessarily give us every little detail. We don't want to take up a whole lot of your time, but just give us enough info so that we can support you in the work you're doing. Because discrimination is nefarious, and it is a great barrier to the success of a lot of other important programs, such as affordable housing delivery, supportive services delivery, et cetera. So I just wanted to make sure to emphasize that. Please do reach out if anything that's been shared so far pulled a string and you said, I think a client of mine might have faced that. I think I may have faced that, or a friend or a family member. Please do give us a call. We really welcome all calls and are here to serve. So now I'm going to be focusing the remainder of the conversation around source of income discrimination and what that means. So last year, a new protection under the Illinois Human Rights Act went into effect. The Illinois Human Rights Act was amended to include, as one of those protected classes that Isabel walked us through, source of income. And under that law, it has been very generally defined by the state legislator. It started off with this very robust, very specific and nuanced definition that would cover all of our bases. But through negotiations with opponents of the bill, we wound up with a much more simplified version. Actually a version that already existed in Cook County and the city of Chicago. It was adopted nearly verbatim. There was some pronoun differences between one act and another, simply for consistency with the existing legislation. So the way the Illinois Human Rights Act defines source of income is simply the lawful manner by which an individual supports himself or herself and his or her dependents. And so basically what we're talking about is any verifiable legal source of income. And I want to emphasize legal. This is a state law. So when we're talking about legal, that would be things like working in the cannabis industry, which is an industry of workers we've seen discriminated against, maybe because they're not banking because of different concerns and regulations at the federal level around cannabis. So I wanted to emphasize that term legal. And then another thing I want to do is, while very simple, very vague, there is a bit of beauty in that vagueness. So this law is being interpreted to extend very broadly to cover virtually every form of legal assistance. And we're going to break that down throughout the conversation. But I want to point out a couple really important words in this definition. The first is manner, right? It says the lawful manner by which. So manner, that doesn't say anything about you went to work. That doesn't say anything about you paid by check, you paid in cash. It just says it's the manner, right? So you don't have to go and punch a clock for it to be a legitimate and usable source of income on your tenancy, your rental application, right? And then it also says supports himself, right? Supports is a very key word there because, again, what that is doing is that is opening up the protection for programs like the Housing Choice Voucher Program, for programs like any rental assistance program, right? Because it is how you support yourself. It doesn't say pay. It doesn't say transfer directly from your account to your landlord's account. It just says the lawful manner by which an individual supports him or herself. So I wanted to point out those key things. If you're working with the landlord, if you are a landlord or a housing provider of any kind, and you're confronted with a new type of income that is on a rental application, and you're not sure if you have to accept it, ask yourself that question. Is this the lawful manner? And is it lawfully derived income? And is it how they support themselves? The answer will almost always be yes. I doubt anyone is applying telling you that they're going to pay you with rent they just stole from the bank, right? It's almost always going to be yes. And so with that definition in mind, what the Illinois Human Rights Act does, and what it kind of already did, right? We just amended the act to add this new protected characteristic, this new protected class, source of income. What it does is it says that you can't discriminate against someone in the process of renting an apartment, buying a home, applying for a mortgage, or receiving housing related services, right? So that goes back to what Isabel was saying about having the freedom to choose, to enjoy, etc., right? So this is all forms of housing. A lot of this conversation around source of income protections, a lot of the debates when the Illinois General Assembly was considering amending the Illinois Human Rights Act were centered in rental housing. But I'm going to spend just a moment explaining that this covers the purchase of housing, right? So if you're seeing ads, for example, that are saying no FHA loans, that would be a prohibited act. That would be illegal, right? Because the way you finance, the way you afford that purchase of the home is the lawful manner by which you are supporting yourself. So that's a really important one. We see a lot of discrimination in the home sales process against FHA loans, against veteran affairs loans, even sometimes USDA loans. And then also there are homeownership voucher programs across the state. For example, Cook County and the city of Chicago have one. And we know that voucher holders transitioning to the homeownership program have been met with a lot of discrimination. And this is just an important distinction to be mindful of. And that includes, well, actually during the mortgage lending process, you actually have other federal protections that will protect public assistance, so that you shouldn't be denied a mortgage because you have a homeownership voucher. So some examples of sources of income that we tend to be most concerned about at Illinois, most concerned about being confronted with illegal discrimination are listed here on your screen. I think the number one and most frequent instance we hear about is the experiences of those using housing choice vouchers. The housing choice voucher program has been in many ways stigmatized and racialized over the years within the housing provider community and just in general by communities when we talk about NIMBYism and other ways that communities will push back and try and erect exclusionary barriers to people with vouchers entering them. So we're going to focus a lot of the conversation on how this protection covers housing choice voucher holders, but I want to be clear that this is also something that veterans are frequently experiencing because of their benefits, because of how SSI recipients are treated when they're applying and listing SSI. There's some stigma against them when the housing provider is reviewing the different types of income that will pay the rent. retirement income, TANF. Of course, other forms of emergency rental assistance. There's probably folks on the call right now who are running programs funded by the state, funded by the township, the county, or just funded internally through your own fundraising and grant making that you do. I'm not certain there's a lot in Illinois, but in the state, there's a lot of experimentation happening with different healthcare benefit type vouchers. There's research being done and pilots being run about like Medicare, Medicaid expansion, like kind of covering the cost of rental housing. I think like in Oregon is one really great example of where that's happening, where they're finding that, you know, if you think about the sort of term that was floating around a lot, housing as a vaccine, that a good healthcare tool, a good preventative healthcare option is to ensure that people aren't experiencing homelessness. Other forms, of course, are Social Security, disability insurance. We will see a lot of, oftentimes what we see with things like disability insurance, child support, and any of these really on here is housing providers will be, maybe they had an experience once and they found that there was disruptions in the payments or there was a delay in getting approved. You cannot use that past experience as a justification to deny all folks with that type of income as of January 1st of last year because of this amendment to the Illinois Human Rights Act. So this is going to change a few things, and some of them aren't super obvious, right? If you're not doing if you're not receiving the calls where people are alleging these different forms of discrimination, you might not have heard of some of these. So one thing this also does, because of that very loose, that very general definition we went over, is it also extends protection because of your occupation, right? Because that's the lawful manner by which you support yourself. During COVID, what we saw, especially in the earlier part of COVID, after things started shutting down, we saw discrimination against housing applicants who worked in the service industry, because there was a fear that the governor would have another shelter-in-place order, and that would disrupt people's wages, especially their tips, if they worked in the service industry. There was also discrimination against healthcare workers, because there was concern that people who were working in hospitals and healthcare facilities, that they would be exposed to the virus and possibly bring it home to their, maybe their apartment complex or whatever. That would no longer be acceptable under this new protection. You cannot outright refuse to accept emergency rental assistance. That one gets a little bit complicated because there are instances when the emergency rental assistance program might have overly burdensome requirements. And we're going to talk about what isn't a burdensome requirement. And the Housing Choice Voucher program is a perfect example that filling out paperwork, doing the inspection, things like that is not a burden. That's just doing business. What I'm talking about is things like in the emergency rental assistance programs, where sometimes there is requiring you to forgive late fees, or sometimes there is requiring some sort of moratorium on the right to evict, things like that, that would significantly disrupt the provider's ability to execute and enforce their lease agreement. And again, I don't want anyone to walk away thinking that those part and parcel, really basic things like paperwork and third-party contracts and inspections would qualify as overly burdensome. We're actually going to talk about a lot of examples of why we know that's not the case. Some other things, you can no longer give preferential treatment to different types of income, right? So basically all income is valid, and you should no longer be like, let's just say you get two applicants, one with a voucher, one with wages from employment. You can't say, well, I want the wages from employment. You really need to be screening them to see who is the most qualified under your existing criteria. So maybe there's a credit score, maybe that's the tiebreaker, maybe it's landlord references. I think it's a much better predictor of tenancy than a credit score ever would. I would actually discourage even using a credit score. Anything that would discourage applicants from applying would be a violation. We do see a lot of that in our investigations, where people just kind of make things up, sometimes intentionally, sometimes out of ignorance, but things like, oh, we don't participate in that program. There's a thought that like many years ago when you had to voluntarily to participate and sign up for it or something like that. Cannot make or cannot post advertisements that discourage people from renting with specific sources of income. The one that we still unfortunately see floating around a lot, especially in places like Craigslist, where a lot of organically affordable housing is listed. You will see things like no Section 8. That is a flat out violation of the Illinois Human Rights Act under this new law. Yeah, and we're going to talk a little bit about it. I believe it's queued up in the slides, but one of the big ones too is rejecting applicants. You can no longer reject applicants who simply can't provide certain documents that would be related to their source of income. So I said that in kind of a confusing way, so I'll give an example. You might see a listing on just an online website, and they'll say, 2 months bank statements and 2 months pay stubs and a W-2 form. If you have a voucher and that's your only source of income, you can't disqualify them for not having that specific piece of paper that you asked for. There needs to be some other supplemental information they can provide to demonstrate their income. We do see that as this sort of not very clever like workaround that people have been trying. It is not a workaround, it is still a violation. It's really just erecting barriers to discourage people from applying. So some other examples we see and still see even after this act and things that we're trying to support individuals who are experiencing these things include refusing to process paperwork or delaying people's paperwork. So possibly canceling the inspections related to the voucher in the hopes that their time will expire or something like that. We're seeing, people who rely on child support and alimony be denied. Again, that goes to what I said before, a stigma. Maybe there's a concern that the person paying the alimony or child support won't pay timely or something like that. That is not legitimate. And another one that we see and sometimes even see at larger housing providers, which is always really surprising, is charging additional fees based on source of income. So we've seen instances where housing providers will charge like a sort of administration fee because you're renting with a voucher and they say it's more paperwork or we have to be here for an inspection, so we're going to charge you extra. That would be a differential term and condition, which is a prohibited act, right? Because it would be on the basis of their source of income. And we'll talk a bit about how that works. So Isabel touched on discriminatory effect, also known as disparate impact, right? And this is when a policy maybe is not intended to discriminate, but has the effect of doing so. So with rental subsidy programs, in particular the Housing Choice Voucher Program, we see this playing out most frequently in issues where a housing provider will say, I take vouchers, I take all income, money is green, but I don't sign third-party contracts. We've actually seen some folks who opposed the legislation that we're discussing now, and who, after it was passed, started trying to coach housing providers to say that we don't sign third-party contracts, thinking that that was some sort of get out of jail free card, because they're not saying we don't take vouchers, we don't sign contracts. Because of the discriminatory effect theory, which has been affirmed by the U.S. Supreme Court and multiple times all over the country, even though the policy, maybe the landlord didn't even do that intentionally and they had no idea, they just don't like the government and they don't want to engage in agreement, or maybe there's some line or something they disagreed with. Because that contract is part and parcel to the voucher program, you cannot rent with the voucher if that contract is not signed. That has the effect of discriminating against every single participant in the program, right? Another way of where we see this play out a lot is in 3 times the minimum rent requirements, which we're going to talk about in a minute. I really want to encourage anyone to ask any questions about discriminatory effect that you might have, or examples that you might want to talk through in the Q&A on Zoom, and we can circle back to it in a bit. So one reason we wanted to talk today and to join you all today is because we've been talking about source of income for quite a while, even before the bill passed, but there's been some recent advancements. So a couple months ago, the Illinois Department of Human Rights, who is responsible for investigating complaints alleging violations of the Illinois Human Rights Act, is the entity you would go to file a complaint if you didn't want to do it in court. They've released a frequently asked questions on it. So it's a somewhat of guidance on how they are interpreting the source of income protection. And one of the questions that they're speaking to in the next several slides I'm going to go through are really pulling straight from them, so that you know that you're kind of getting it from the horse's mouth, and that you can feel comfortable advocating for your clients from this information. We'll give you links and stuff so that you can just copy paste if you want, so that you can send links to landlords who maybe denied your client. You're saying, well, you can't do this, here's why. So one thing we hear, a question we all hear a lot, and that the state has finally opined on, is the question of, is renting to a voucher holder mandatory? And the answer is no, right? But it's no in the same way that it is not mandatory to rent to anyone in the United States, right? So what these discrimination protections do is they say, you can't deny me or treat me unfavorably or differently because I have this protected characteristic, because I belong to this protected class. But you can still have your requirements, right? So you can still deny a person with a voucher because they didn't meet your other requirements. It just can't be that your source of income is a requirement, a particular source of income. So a really easy example would just think that to think around the fact that, you know, it's been illegal to discriminate against someone on the basis of their race since 1968. So if there's no law that says you must rent to every person of race X who applies there. What the law says is you can't deny someone of race X simply because of their race. That would be discrimination. There is no mandate. So we want to clear that up and help other advocates be able to have those conversations with landlords, because we do see that as sort of just a really weak argument that can sometimes people can talk circles around. A really important thing to understand around all of this and advocating and supporting voucher holders and subsidized renters is around how their income will be calculated. So obviously we all know that rental subsidy programs are designed specifically to support people of limited financial means, right? There's some justification, some reason, some experience that is making it difficult to afford rent. Housing is a human right, it's a necessity of life. So there are programs to support people with meeting those needs, being safe and stable, like the voucher program. Those programs are means tested, right? They're designed only to support those who actually need the financial support in order to make it. So having overly burdensome income requirements, minimum income requirements, will have that discriminatory effect of denying everyone with a voucher or whatever the subsidy is. So the Illinois Department of Human Rights directly addresses this in the frequently asked questions, which we'll link to. And if we use this example here on the screen, we can kind of think through what that looks like and what that means in practice. So if we imagine a rental unit that is being advertised for $2,000 a month, the housing provider might have a requirement that they earn 3 times the rent in order to qualify. They want to know that they have the means to regularly and consistently pay their rent on time. Sounds fair enough. But the problem is you cannot qualify for a voucher and earn 3 times the rent, right? That is not the group that these programs are designed to help. It's designed to help people who are struggling to afford their rent with their unsubsidized income. So in this instance, with a voucher, you have the $2,000 a month rent. You can't earn the three times or $6,000, but your housing choice voucher will cover $1,500 a month in rent, right? We kind of are just making up an example here. It'll cover $1,500 a month in rent. That means that the voucher holder's tenant payment portion, the portion they are directly responsible for each month, is $500. Under this law and under the guidance offered by the state, the housing provider could reasonably apply that minimum income requirement to their tenant payment portion. In this case, the remaining $500, which would be $1,500 a month. So in short, when you have a voucher, the minimum income multiplier or threshold cannot be applied to the total rent amount, can only be applied to the tenant's payment portion. A question that has come up quite a bit also is around if existing tenants are protected based on their source of income. So whether or not it's only when people are applying or already in place. The answer is everyone is protected regardless of where they are at in the process or in the relationship with rental housing. So if you, let's just say you're renting a place now and you are on a voucher waiting list or some rental subsidy waiting list, you've been paying out of pocket, you've been doing everything you can to make ends meet. And then you get picked on that waiting list. You cannot be treated differently. They need to go through all of those steps. They can't say, oh, well, circumstances have changed now, or I never would have rented to you. That would be discrimination under this protection. One thing that kind of surprised us in the state's guidance was around credit scores. It was a happy surprise. We weren't expecting them to issue any statements around this, but they did. And it was around if housing providers can require a minimum credit score. And as you can see on your screen, the answer is yes. But they've actually said, and this is the first time I'm aware of the state saying this, that credit score requirement could have a discriminatory effect. It could be a barrier. So if you're seeing that happen, I think examples, we would love to talk to you or the client being affected. I think some examples of types of matters that the law might support exploring would be things like this person has a voucher that covers 100% of the rent, but is being denied because of their credit score. Well, what business application does that credit score meet if 100% of the rent is being covered, right? The credit score is used as a predictor, not a very accurate one, but an allowable one of whether or not you can pay your rent. Well, if you don't have a personal rent burden, then it shouldn't matter. And there's all sorts of different scenarios where something like that could play out. If you're running into that or have clients that are, we'd love to think through that and see if there's a way we can leverage either the Illinois Human Rights Act or the Fair Housing Act to support that person. So, like I said, some of about the last 5 slides, we're sort of synthesizing some of the information on the Illinois Human Rights Department's FAQ on source of income. On your screen now is a QR code. You can scan that to get to that page. It's a really useful page. There's actually a lot more that's being discussed than what I touched on. I think kind of organically, we probably covered a lot of it, but it's a really useful, easily searchable tool. And it's a really great advocacy tool if you're outreaching a landlord who's denied your client and you just want to try and mediate the situation to say, you can't do that, here is why. So this is an example of what the website looks like, just to help you make sure you're finding the right place. I think it might still be listed in a banner at the top of the screen if you went to Illinois Department of Human Rights website. So we want to make sure everyone understands who's liable under these fair housing laws, whether or not it's the Fair Housing Act at the federal level, the Illinois Human Rights Act at the state level, or one of the local protections under ordinances. It's really everyone. Anyone who's involved in the housing transaction is liable. You see a list on your screen, but the most obvious, landlords and property owners. It is extended also to the appraisers and lending industry, real estate brokers. There's no cushion given. If a housing provider instructs a real estate agent to discriminate, they're both liable. You know, the real estate agent in that situation should say, I can't represent you. This is illegal. It's my job. I have a fiduciary responsibility to advise you can't do this, and therefore I cannot take you on as a client. That should be the outcome. Unfortunately, we don't see that. If you had access to the MLS, the multiple listing service, you would actually find that there are illegally discriminatory ads listed by professional real estate agents. It's quite frustrating to see. This also extends to insurance companies. Insurance companies should not be treating homeowners any different because of their source of funding. And it should also not be treating housing providers any different because of their source of funding. We do hear stories of landlords who intentionally rent to voucher holders being denied coverage. We hear stories of affordable housing developers being denied coverage or being booted to sort of the secondary, less ideal insurance market. The newspaper or media outlet that publishes the discriminatory ad is liable, just as the person who paid to have it published. Really, everyone is liable, even neighbors under the Fair Housing Act and Illinois Human Rights Act who are, harassing people. I think an easy example to relate to, and that everyone's probably heard stories of, is like racial harassment or harassment against people of certain religions. That prevents you from enjoying your home. So that is robbing you of your freedom to live in the place you choose. So in terms of who has these rights, who has standing, what we say when we say who has standing is who has the ability to bring a claim under these acts, who has the ability to say my fair housing rights were violated. A lot of us, any person certainly does if they have experienced one of these forms of discrimination. But also the thing we like to really emphasize is that organizations do too, right? This is one of the tools. It's referred to as organizational standing that Hope Fair Housing Center uses to disrupt discriminatory practices and to try and bring about change in communities. So if the organization you work for, or maybe you're a consumer and you access the services of one of these organizations, if their work is having to divert resources or spend money and labor and materials to combating discrimination, to overcoming discrimination, and if it is frustrating your mission, so that would be examples like when it's undoing the good work that you're doing, then you have standing. So an example of that might be if you're an organization that provides, helps people secure rental subsidies and locate landlords that accept them to help them lease up and navigate the market. Maybe you're assisting people with disabilities with transportation to get there. And you're running into landlords that are refusing to accept your clients. Not only does your client have a discrimination case that they can bring forward, but so does your organization, because your organization's mission is being frustrated. It's preventing you from doing the work that you are designed to do, and it is costing you resources, right? So every one of those car rides is time you have to spend, is money you have to spend, and you could have spent less had the law just not been violated. So you have the right to bring forward discrimination complaints. We'll talk about the venues where you can do that. But one reason we wanted to bring that up today is because it's really important for organizations to think through if they are ready to say enough is enough, and we're going to exercise our fair housing rights to stand up for the folks we serve. So what we realize at Hope is we get a lot of calls from people who have undoubtedly experienced illegal discrimination, but who just don't have the desire to become fair housing, civil rights activists, or who are concerned about blowback or retaliation for legitimate reasons, even though retaliation is illegal, who just don't have the time, or maybe it's just that they have greater priorities right now. If you're looking for housing right now, and even if it's just yourself, but especially if you have, small children, like that is an urgent and time-consuming thing, and you don't have the capacity to go through those steps of filing a complaint. So it's very important that organizations look to exercise their rights to stand up for their clients. We hear often and are very empathetic to the fact that advocacy organizations have to walk a fine line and build relationships so that they can house their clients. Let's just say build relationships with housing providers. But I just want to remind everyone, if there's housing providers, especially some of the larger ones who are discriminating against all your clients, there's no bridge you can build until you leverage the law to force them to change that policy. And your organizational standing is a tool you can use to leverage the law to not only recoup the damages experienced by your organization and your client, but to force policy change, to force that entity to stop discriminating, to get training, to affirmatively make available those units that were previously being denied illegally. So just share that. And I'm gonna step off my soapbox now. So under these, we've talked about two protections throughout this conversation, the Federal Fair Housing Act and the Illinois Human Rights Act. So under the Federal Fair Housing Act, you have 1 year during which you can file a discrimination complaint with the U.S. Department of Housing and Urban Development. This is a free process. It's a very neutral process. It's pretty straightforward and simple. This is something that HOPE assists with regularly. But the key thing is it's free, and the threshold for bringing that complaint is much simpler. It's much less intimidating. It's much more accessible. However, you only have that 365 days. Similarly, if you're bringing an Illinois Human Rights Act claim, which is where that source of income protection is, you have 1 year to bring your complaint to the Illinois Department of Human Rights. You can also bring any federally protected claim to IDHR. They are what's called substantially equivalent. They are able to investigate that on behalf of the federal government. So you have 1 year to file with HUD and 1 year to file with IDHR. If you want to bring your matter into court under both the federal protections and the state protections, you have 2 years. So you have 2 years from the time that the discrimination occurred or stopped to bring your matter forward, to file a lawsuit. It's important that you have that extended period of time, because filing lawsuits are more complicated. You have to get counsel. There's just a higher threshold to bringing that forward. And this is, again, is something that HOPE can help with. A lot of what we do is we help people meet that threshold. They say, I know this happened. I know I was discriminated against, but I can't prove it beyond this feeling in my gut. It's our job to prove it and to build that evidence so that you can get your justice accessing either of these venues. And we work, we'll either represent the person in the administrative venue like HUD or IDHR, or we will work with private attorneys to bring the matter in court. So next I want to talk about our source of income advocacy toolkit. So we created some tools. Source of income discrimination is so common. There's about 100,000 voucher holders, for example, in Illinois alone, not to mention people receiving all these other types of incomes that are protected and working in these industries that are experiencing discrimination. So we started working on a project to start building some self-advocacy tools for folks. We were recognizing that we can't assist every single individual with the need. The need is just too great. So we've made some pretty accessible materials available on our website. If you were to scan the QR code on your screen now, it would take you straight to the web page. Everyone's going to get a copy of this, so it'll be easy to get there. If you go to our website, there's a little tab that'll take you to the toolkits, and it'll bring you to this page. We have a couple of toolkits available. Another one that will be posted really soon is for advocating when you're being denied due to an eviction record. Another one will be about dealing with appraisal discrimination, and then there's one on there now for arrest and conviction record related denials. So if you went to, well, I'll just kind of walk through it. So in this toolkit right now on our website, there's some Know Your Rights handouts if anyone wanted to print them and give them out to their colleagues. If you needed copies of these, let us know, and we can probably mail some professionally printed copies. And what all this does is it's designed to kind of inform you on what your rights are, and then to walk you through how to use these advocacy letters. So we have 2 types of letters. Ignore the screen here. It says that there's one for Cook County, but we no longer need that one because the state issued their guidance, so that one's removed. But there's 2 types of letters. One is a general letter for my source of income has been discriminated against, and the other is specifically about when the discrimination you're facing is related to minimum income thresholds. These letters take really simple formats. They're designed to be accessible, that you don't have to be an expert. It's meant to be a tool to help you exercise your rights and to stand up for your rights. And all they do is describe the violation. So they help you with kind of citing the legal code. they direct the provider to fair housing law and guidance so that they can validate and so that they understand that you're not just making things up. And then they kind of help you ask for a very direct and ideal outcome, which we'll talk about. So again, there's the general letter, which is just any instance related to source of income. And then there is the minimum income letter, which will be when someone is denied because they applied and they were told they didn't meet the minimum income, but they had a voucher and should have been qualified. So in the general sample letter that you can see here, it is just like I said, it's very clear. It's just 3 very brief paragraphs. It's all kind of formatted for you. You just have to plug in, there's little cues telling you what to put where. So you're basically just telling them a description of the discriminatory act, what happened. In this example, the person completed an application and 2 days later, she was, received a return call saying we don't accept voucher holders. So we have prompts in there directing you to just very briefly say what happened. The information on the law that has been violated is preloaded in there, so you don't have to do research, you don't have to have expertise. And then there'll be prompts again, instructing you to list an ideal outcome and offering examples. So in this case, maybe the person says, I want you to reconsider my application. You illegally denied me. You need to make this available to me. I want to live there. This is best for me. Another person might say, I don't ever want to live there. You disrespected me. You disrespected my family. You're not the housing provider for me, but I do want my application feedback, right? So those are types of examples we suggest to people. And of course, the sky's the limit. People can define justice for themselves in their own self-advocacy. And then we'll encourage everyone to provide an email address, because it's always best to communicate in writing. So that way you get the response in writing, and to include a requested response date. Because in this rental market, things aren't available for very long. So it is very important to put the expectation on how long they have to respond. And I can share with you in our own experience, people are pretty good at honoring that requested response date, because you are very clearly explaining to them that they broke the law. And here is the minimum income letter. It functions basically the same way. It just has some different fair housing guidance included in here, specifically related to the FAQ that the Illinois Department of Human Rights has issued, quoting their information on 3 times the rent on minimum income. And it also includes references to both the Cook County and Chicago Commissions on Human Rights guidance on similar topics. So this is just, if you're in the city of Chicago, it becomes even stronger, because now you have every level of government backing you up. So in terms of when you're using these, or, if you're an advocate supporting a client using this, if you're a client or a consumer who would be using this yourself, just a couple of tips. Just be specific. You don't have to be long-winded, but you do need to be specific about, for example, who you talked to, what was said to you. You do need to give a reasonable deadline. So I don't think it would be necessarily reasonable to say you must meet my requested demands by 2 days from now. But I think a week from now, a business week, is very reasonable. They might need a moment to consult or to find an alternative. Maybe that unit is gone now between the lag, and they need to find another one that they can offer you. And when you're using the self-advocacy letter, you need to know and explain what your desired outcome is, right? So reconsider your application, refund the fees. In the example of the unit is no longer available, maybe it's making a similar unit available to you at the same price. We've been very successful in that advocacy, where people have contacted us that were discriminated against. And we said, well, so what if the unit's gone? It never should have been gone. It should have gone to them. So I know they applied for a 2-bedroom, but you're going to have to give them that 3-bedroom that's available now. Otherwise, they have rights that they can exercise, and it's a lot more expensive to settle a lawsuit. And you just kind of, if you are an advocate, you will have to tweak it a little bit to make it clear that you're communicating on behalf of another person. So the template is written for an individual directly impacted to use it, but we had advocates in mind. You'll just have to tweak a couple little things that should be pretty straightforward and easy to do. So when you're on our webpage and you're at the toolkit section, if you clicked on the source of income one, all you have to do to get to these is just click one of these icons that are circled on the screen. And you can just click that download guide icon to get a copy of it, of the Know Your Rights materials. If the advocacy is not successful, then that's when we really, really suggest that you contact Hope Fair Housing Center. Like I said before, we're taxpayer funded. We're here to serve. It is our job. It is our duty to support people when they've experienced discrimination. So one of the ways we structured the self-advocacy toolkit is to encourage things to be in writing so that it makes it a bit easier and quicker to do the work we need to do to help exercise fair housing rights. But please do contact us if you've used the self-advocacy toolkit and the request was ignored or denied. Or if you wanted to bypass Hope, that's totally fine and totally your prerogative. You could go straight to, as I said before, the Department of Housing and Urban Development or the Illinois Department of Human Rights to file a complaint. If you're in Cook County or the city of Chicago, you can file at those levels of government, and then other places like Urbana as well have source of income protections. And then, as I said before, you have the ability to work with an attorney to bring it to court. We also, and this I think is the last thing I'm going to share before we switch over to Q&A, wanted to point out a really great tool that was created by Law Center for Better Housing. It's called Rentervention. So if you just Googled Rentervention, you would find it. It's not live yet, but it will be soon. So they're taking some of these advocacy letters and they are plugging them into their chatbot. So basically you would go to their website and start talking to Rennie, this little apartment shaped robot here, and start telling them about your housing problem. And if you're stealing a source of income protections, it will eventually soon be able to create those letters for you. It'll ask you questions and then fill it out. And we'll even take it so far as mailing the letter for you. So you don't even have to go to the post office or pay for a stamp. And they help with lots of things, really important things like evictions and utility shutoffs, problems with security deposits or housing conditions. They've updated it recently to include things around Violence Against Women Act issues and sexual harassment. And they're ever expanding, of course, in places where there's more robust landlord-tenant protections, like in the city of Chicago. They're able to offer more comprehensive support through this AI tool. But I wanted to call this out because, you know, even in other places that don't have landlord-tenant protections, there are some state level protections, including things like anti-discrimination protections that this tool can help with. And again, it is ever improving. So just wanted to give a shout out to folks at Law Center for Better Housing who are doing some really cool work, making AI, at least in this instance, not scary. So give us a call if you believe you've experienced discrimination, a client has, or if your organization is interested in exploring the rights they have. We will screen the call to figure out if we think there is a violation, and then we will open an investigation and look at all of our options. All our contact info is on the screen now. And again, you'll get a copy of these slides. I'm going to pass it over to you, Shelley, but we do have time for Q&A.
All right. Thank you very much, Michael. To Michael and Isabella, I want to say that this is the best presentation that I have ever heard on the fair housing and source of income. I am so happy that you presented this today. It's made things much more clear to me. And what I really appreciate is the organizational standing. I never thought about that. And, you know, when I was working as a community reintegration specialist, I did spend a lot of time searching for housing, hours of my time searching for housing to move people out of nursing homes. And I think this is a new tool that our Centers for Independent Living, and I know it's hard when you're trying to build a robust rapport with your local landlord associations and your local landlords. But like you said, if you do have one entity that seems to be running a biggest part of the show and they are clearly discriminating, then I think this is a new tool that we can use to help in that situation. And while we're waiting, I wanted to ask you something. You said that the media that is advertising, letting the landlords advertise wrong things or discriminatory things could be held liable. But what I have found lately is most everything is being moved to Facebook groups. And so how do you go against something as big as Facebook?
Yeah, so the online ads, and I should find a way to remind myself to call attention to that. The online ads get a little complicated. So there was actually litigation in the Chicago area challenging Craigslist for
Mhm.
allowing the posting of this, and there's I forget the specific act that gives them a little bit of flexibility to subvert the law. The advocates who were challenging Craigslist were not successful. Basically, they had a free pass. It's the poster that was liable. Newspapers are certainly liable. If you ever
Mhm.
seen a newspaper, those equal housing ads in the rental listings, it's probably because they got sued and they have to put it in there at the settlement term. Facebook, we've seen some successes there. So some of our friends at the National Fair Housing Alliance, the Fair Housing Justice Center, and another group whose name is escaping me, actually sued Facebook for the way they allowed filtering in their advertisements. They could allow
Mhm.
you to target your ads where you could just say, people who are white, this ad will be seen by white people. That had the effect of steering, right? Because now only
Wow.
people of one race can see it. So they settled that case. Actually, the United States filed their own complaint. The DOJ sued Facebook as well. I think there's a lot of exploration that needs to happen and whether or not Facebook is liable, but certainly the poster is liable. So we see a lot of agents listing on there and we see a lot of landlords listing on there. And if they are, that entity can certainly be challenged using the law.
Mhm. Carrie, do we have any questions in the question and answer?
We do. Um, excuse me, Teresa says, this is very, really, excuse me. This is very informative. Thank you. Are landlords informed of these laws or are we providing education to them?
So yeah, we do a lot. I want to just say, so in giving these trainings, it's always hard to walk the line because we talk a lot about things that landlords can or could do, or we talk about real examples that our clients have faced. But we are not enemies to landlords. We work very closely with landlords and real estate agents frequently. I'm joining a real estate affinity group this evening to talk about fair housing. I would say we train housing providers at least as much as service providers because they're touching, sometimes thousands of units. So they are. Some property managers are required to get licensed through the state and they have to take some tests. Real estate agents have fair housing course requirements and they're only getting stricter. And groups like the Illinois Association of Realtors, they didn't wait for the state to issue their guidance. They issued very, very broad and strong guidance to their members on how they should be following this law. So they've been doing a great job. They actually joined on and supported the legislation towards the end, right before it passed. And the National Association of Realtors has been turning a new leaf on this as well. So they are. What we find a lot of is it's hard to break through stigma. Maybe the boss knows what's going on. Maybe the boss is feeling good about fair housing, but it's the person who hasn't been as well trained, who's coming into their work with, with their friends or their neighbors or whatever, one of the socializing factors said about this group or that group. There's also folks who've been in the industry for a long time who, remember a time when the program was quote unquote voluntary, when it did require advanced participation. And there's just a lack of, they're busy. And so we get out there and we try and refresh people. But at the end of the day, if you're harming people, ignorance is not a defense. Anyone who's harming people needs to be held accountable.
And lastly, you're going to share these slides with me so I can get them out to everybody?
Correct. Yeah, Isabel, can you shed light on what we will share? 'Cause are we gonna have the links and everything too for folks?
Yes. So in the next day, I can send out a PDF copy of the slides that you saw today, and then links to all of the resources. So you can have that for your own records.
Now, I want to let our participants know if you are unable to enter your question in the Q&A section. If you will raise your hand, Tara has the participant list in front of her and she can unmute you so that you can ask your question. While we're waiting on that, do you still have the need for testers?
Mhm.
Okay, if you could talk about that for a
Yeah,
little bit too.
so thanks so much for bringing that up, Shelley. So, one of the, we talked a lot about how what we do is we support victims of discrimination with building their case, with proving that it happened. It's not just he said, she said. It's a necessity to have strong evidence. And what we do is we do a variety of different investigations. We do data analysis, mapping, all sorts of different things. One of the big things we do is testing. So what we're doing is we are bringing on people who will sort of reenact the circumstances. Let's just take an example of a voucher holder. Someone, tried to rent with a voucher and they were told we don't take vouchers, but that all happened on the phone. They can't prove that happened and they want to file a complaint. So we will use testers who will kind of recreate that experience. One will call to inquire about the unit with a voucher, one will call without a voucher, and then we will compare experiences to see if those independent, neutral, unmotivated individuals can verify that experience. The person who said they had a voucher was told we don't take them, or was told the unit isn't available, but then the person who didn't have the voucher was told, come on in, we'd love to have you. This is going to be a great place. That's how we corroborate. That's how we prove. It's a very, very important tool. It's a tool that helps in individual instances of discrimination all the way up to systemic bank, lending discrimination. It is very important. And we need testers to do that work. They are compensated for their time with a stipend. The stipend ranges based on the sort of the rigor of the type of test. We need very diverse groups of people because we cannot corroborate someone's experience unless we have a tester with a similar characteristic. So we are always looking to expand our pool. I will say it's not steady work. It is more civil rights activism that you are reimbursed for. All your travels covered, all of that. One area that's really important to us is around design and construction. So we do testing to ensure that new developments are meeting the Fair Housing Act's requirements for physical accessibility, things like thresholds, doorways, reinforced walls and showers, things like this. And we really need testers to do that. And no one's better equipped to determine if something is accessible than someone who is experiencing an ambulatory accessibility need, right? So we are always on the lookout. Stipends range from anywhere between like $65 and $120, depending on the test. And again, we reimburse for all mileage and all that. Please give us a call if you're interested or know someone who is.
Great. Any questions so far, Tara?
Nothing.
Okay. Well, if all minds are clear, I again want to thank Michael and Isabella from Hope Fair Housing for this presentation today. And as Isabella said, we will get this presentation to you along with the important links. Love the links to the letters. Oh my gosh, that's a fantastic thing to be able to just pull up a letter like that and use. So we appreciate that. Also, we will have the recording of this webinar within the next 48 hours. You will access it on the Statewide Independent Living Council's website, and it will take you to our YouTube channel where you can review this recording or share it with other people that weren't able to attend today. And with all that being said, before we sign off, let me remind you that there is a brief survey. I think it's only like 2 or 3 questions. When we sign off, please take that survey and let us know what you think about today. And with that, I will give you the rest of your afternoon off. Thank you very much for your attendance. Bye-bye.